Hello and welcome to another view from Mayor Brown. This sits alongside our regular podcast and is an occasional series of interviews with those involved in the changes going on in employment law. The podcast is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to another view, which is our special guest edition of the Employment Podcast. I'm delighted to be joined today by Naomi Ellenbogen QC because she's really rather impressive, don't you know? And she was the lead representative in the Essop case, and she's here today to talk to us about that case. For those of you who haven't worked with Naomi before, she was at school in Liverpool. She went to Oxford University. She's joint head of Chambers at Littleton Chambers, with whom we do a lot of work. She's a recorder. She's vice chair of the Bar Standards Board. And according to her bit of blurb on the internet, she's both fiercely intelligent and she's really, really nice to deal with. So we're hoping for the really nice rather than the fierce bit, please, Naomi. But welcome to the podcast.
Thank you.
So let's start with the background to the Essop case. What was underlying, factually, the background to the Essop case?
The background to the Essop case was the civil service requirement as it then applied for grades or people applying for grades at certain levels to sit what was called a core skills assessment. And as the name suggests, that is a test which measures your ability in certain skills common to all jobs at that level. You have to pass that test in order to move to the job-specific test for the job for which you're applying.
So it's like a sort of an initial step before you could get through. Right,
exactly.
Okay. And what was causing concern, and why did the litigation arise?
The litigation arose because when statistical analysis was done by certain occupational consultants, it was found that people of a certain age and above and of a certain ethnic background were disproportionately failing the test. So they were more likely to fail than white or, as it was put, younger candidates, although the age in question was 35. So that's rather a sobering position.
You have to be a particular perspective to think of that as younger. Yes,
absolutely.
Agreed. Let's move on.
Yes, quite.
Okay, and was there an explanation for why this was happening?
No, and that was ultimately what gave rise to the claim. Everybody knew that it was happening. The statistics were clear. What was less clear, indeed unclear, was why that was the case, and such analysis as had been done simply had not got to the bottom of that.
But the statistical pattern was completely clear. This wasn't an aberration. This was an issue. The question was how the law would address that issue.
It was, although what it leaves open as an issue, because this matter will be remitted following the Supreme Court judgment, is quite how one describes the ethnic grouping. So in order for the statistics to be reliable, anybody that fell into the generic category BME was comprised or fell within the statistical grouping.
I saw that in the decision, yes, and I hadn't appreciated quite what the significance of that, but that was how the statistics were done.
Yes, so the question that arises is whether if you break down those statistics into specific ethnic groups, whether you get the same reliable findings and whether that matters, and that's a separate issue when the matter's remitted.
Okay, so what claims were being brought by the claimants then? Presumably they were being effectively screened out or impeded but for career progression purposes.
And they said that the requirement to sit the core skills assessment was a provision criterion or practice, a PCP, which disadvantaged them disproportionately. And so depending upon the background of the particular claimant, that person sued for race and or age discrimination as a result. They said it was indirectly discriminatory to require them to sit an assessment where they were disproportionately likely to fail compared with their comparator groups.
And so presumably there would have been no dispute that this was a PCP, so the question would then hinge on whether it was indirectly discriminatory and whether it was justifiable.
Yes, precisely. And you're absolutely right, it's clearly a PCP. The question is, and even before one gets to justification, whether or not the twin requirements that were in focus were satisfied. So whether the group was suffering from the particular disadvantage for the purposes of Section 19(2)(b) of our domestic legislation of the Equality Act, and thereafter whether each individual was suffering from, as the wording of that Act requires, that disadvantage.
Okay, so as I understand it, going up through the court system, each court reverses the decision of the court point until you get to the Supreme Court.
Yes.
So, in brief, in front of the Employment Tribunal, the outcome was favourable.
And I can't take any credit for that. That was my junior John Paul Waite who succeeded before the Employment Tribunal. I also can't take credit for his failing before the Employment Appeal Tribunal. We then both succeeded before the Court of Appeal, and in the Supreme Court, it would be fair to say we came second.
Right. Plot spoiler for those of you who don't know the outcome. Yes. Right. Okay, so by the time the case has got to Supreme Court, what are the legal the legal questions that the Supreme Court is being asked to decide?
The legal questions were beguilingly straightforward. The answer is perhaps less so. The legal issue was, given that the group disadvantage and the individual disadvantage have to coincide in order to satisfy the requirements of the statute, the question was, could you be certain of that in circumstances in which the reasons for the particular disadvantage were unknown? I'll give you an example of how that might arise. Let's assume that instead of the reason being unknown, it is said that those within the BME group were disadvantaged because of some socio-economic disadvantage. And let's assume that the individual claimant could show that he or she was also at that socio-economic disadvantage. The implication would be, or at least could be, that the disadvantage affecting the group was the same as the disadvantage affecting the individual. And if that were right, you would move to the final requirement as to whether justification were required.
Right.
Here, we don't know the reason why either the group had the statistical result that it did, or indeed why any individual did. So, to take an extreme example, if the group failed for some socio-economic reason, or disproportionately failed for that reason, but the individual failed because he didn't turn up to take the exam, there wouldn't be a coincidence. There wouldn't be that disadvantage from which the claimant was suffering. And we said it's for the claimant to establish what underlies the problem with the group, that same problem affects the individual claimant, and only if those two requirements are satisfied do you move to what is 19.2d of the 2010 Act.
So, in essence, putting it into sort of lay terms, if you can't work out why there is a disproportionately detrimental impact, the argument was that you could never be certain that an individual claimant has suffered that detriment rather than some other unrelated and entirely innocent detriment, innocent cause for the detriment. From the claimant's point of view, how did they meet that argument? What were the argument they were putting forward to say, no, this is fine, we can rely on the statistics alone to establish disproportionate impact and take it from there? Well,
the claimant's approach fell into a number of lines of argument. The first was that failure alone of the test, coupled with the group's greater propensity to fail, surmounted the various hurdles that they needed to surmount. As a nuanced approach to that, there was also the suggestion that in the absence of any other reason which promoted itself as applicable to any given claimant, you would have to presume that the reasons affecting the group affected the claimant. So there wasn't a separate requirement, if you like, to establish the reason. It may be that in a given case, a respondent employer could establish that a particular individual, to take my example, hadn't turned up for the test or hadn't revised or whatever it might be. But subject to that, the presumption was that the mere fact of failure, coupled with the group's greater propensity to fail, would result in you surmounting those two hurdles.
Okay, so how did the Supreme Court decide matters at the end of the day? You've alluded to the fact you came second,
yes.
So no shocks, but...
No shocks. The Supreme Court, there was one judgment which was said to be unanimous, and that was Lady Hale who gave the judgment. And she said, first of all, that there was a desirability in indirect discrimination law being simple and not over complex. She said that when you looked at the greater propensity of the group to fail and the fact of failure, the disadvantage in question was simply failure, and it didn't matter whether you looked at that as a greater likelihood of failure or actual failure, the disadvantage, the underlying disadvantage, was the same. And therefore it would be for a respondent, in essence, to show objective justification, and that there should be, as she put it, no shame in that. So the thrust of her judgment, and I hope I don't do it a disservice, was to say that there is a tendency for people to feel that there is a degree of stigma or something inappropriate about requiring a respondent objectively to justify its, in this case, test. That should not be considered to be the case, and that if the test can be objectively justified, it doesn't actually matter whether it has a disproportionate adverse impact. If it can't, then clearly it does, because the requirements of the statute would be satisfied. And she held that to be consistent with the development of anti-discrimination law both in Europe and domestically.
Yes. I thought her judgment was very clear. Whether you necessarily agree with the outcome, and I would ask you to say no, God, of course not. But I thought it was a very clear and measured judgment. And I suppose the point, sort of standing back at and looking at this, if the PCP is the employer's PCP, then to the extent that there are unknowns or uncertainties about its impact, it seems logical that that risk of the unknown lies with the employer, which after all is the one that sets up these arrangements, rather than the claimants, who have nothing to do with the imposition of the exam that they have to pass through. That's merely the framework that they're given to work with. And so they can't, if the employer can't work out why this has a disproportionate impact, to deprive them of a remedy because they can't work out why the disproportionate impact is occurring would seem to be placing the onus on the wrong party.
Yes, and one can see that, as ever in this area of law, policy judgments come into this, and one can see how the argument runs in that direction. The counter-argument is, of course, that if you are bringing a claim and if there are certain statutory hoops through which you must jump, then until you have jumped through them, you haven't actually established either locus to bring the claim or substantively the particular hurdle. The difficulty is that this particular issue had not had to be grappled with before, and in virtually all of the cases on which each side relied, the reason underlying the particular disadvantage was known or readily inferable. And so this was the first case, certainly of which the parties were aware, and seemingly any of the courts were aware, that actually tested this point at an extreme.
Well, it was a pure point. The statistics alone get the claim off the ground such that potentially the employer then has to justify.
Precisely. And because statistics by their nature deal with group behaviour or group outcome, the question is to what extent they can establish an individual disadvantage as distinct from the disadvantage to which the group is subject.
So what did the Supreme Court say about the impact on the individual? Because take your example of the person who doesn't turn up for the exam or turns up very late. In a sense, do they address that in the decision in terms of if statistics are enough to establish the group impact, how does that deal with your second point, which was about the impact on the individual needs to be the same impact as for the group for the individual to have the claim?
It doesn't directly deal with that point, and the reason it doesn't directly deal with that point is because, having construed the disadvantage as lying in the fact of failure as far as the individual is concerned, Lady Hale in essence says you've got the statistics that prove the group disadvantage, you've got the fact of failure in relation to the individual, and it's left by implication for the respondent, if it can, to perhaps call evidence in respect of other features which might have explained or at least contributed to the failure in the individual case.
See, there's going to be an awful lot of scanning people's social media to see who was out the night before the exam having
Possibly.
Again, couldn't comment. Is there any sense in which the unknown, the fact that the reason for this adverse impact is unknown, may play through into the justification? Because if of a test that no one can point to any bit of the test that is offensive in the widest sense, whether that has any impact to the justification or would make it easier to justify a policy that ought to work, but has had this disproportionate impact.
Well, these are amongst the many questions now left open on remission, because the Supreme Court judgment says nothing of what might constitute justification in this case, nor is that surprising, because
sure.
it simply wasn't faced with that issue. But one would now go back to the tribunal to advance all the usual sorts of considerations in relation to objective justification, which of course applies to the PCP specifically rather than its application on any individual. So
Yes.
one would be looking at, amongst other matters, what it is that is necessary for, or why it is rather that this test is necessary for the particular function, why, if it has this disproportionate impact, that impact can be justified. And as we know from many cases, not specifically this one, where there is something which is capable of objective justification, the fact that it has the disparate adverse impact will not of itself or by itself make it discriminatory.
So it's very much still all to play for.
Very much so. And of course that's
imaging.
only one issue in the case. I mean, these claims were commenced across 2012 and 2013. These were test cases. There are any number of individual issues affecting the claims which have nothing to do with the matters before the Supreme Court, and all of those will need litigating in the usual way as well.
Gosh, quite a bun fight. Well, let's talk about what it means for other employers, because when I was reading the decision, it strikes me it's asking a very pure question, which is, statistics alone, no other sort of surrounding explanation as to why
Yes.
this impact is happening. But I think you said yourself that this question had not come up in front of the courts before. But it was clearly felt to be a sufficiently important point that the Supreme Court was willing to hear the
Yes.
case. So what's the significance? I mean, I appreciate the intellectual purity of the answer, whether you agree with it or disagree with it. But what's the significance for employers in the light of this case, when surely most of the time you're going to know why there's a disproportion, or you're going to have a very good idea why there's a disproportionate impact?
Yes, I mean, you may or may not. I think one of the reasons why this case was a paradigm example, apart from the point that you raise, is that the facts were beguilingly straightforward. So it was a good case on which to test the principle at its extreme. As you say, in many cases you might have an inkling as to why there's a problem. You wouldn't necessarily know the full suite
Sure.
of reasons. So for that reason, it was a good test case, and it obviously raises an important point. But for employers generally, first of all, I think strategically in litigation, it may affect the way they approach matters. And as we all know, in discrimination claims, a number of issues can arise. How those are parcelled up, when they're heard, at what
Yes.
stage they're heard, in what order they're heard, is often something which, as a litigator, we spend lots of time, or as litigators, we spend lots of time considering. And questions, I think, which will now arise will be the extent to which objective justification is now placed front and centre.
Yes, I can see that.
It may well result in employers giving more careful thought, in the hope of avoiding litigation, to why their particular form of test or assessment is required in relation to particular job functions than perhaps they might have done before. They might have taken a view that that is something which, if it got to litigation at all, was likely to be very much an end-stage position. And so I think it may change people's litigation strategy. It may make people more concerned to look at why it is they are imposing certain requirements in the first place. It isn't actually a particularly uncommon phenomenon, notwithstanding the absence of a case that has tested it at this purity. If you look at statistical analyses of how certain ethnic groups perform in education,
Yes.
perform with access to certain facilities and so on, you find similar statistical phenomena. And in fact, we looked at some of those in the course of, that is, the courts looked at some
Yes.
of those in the course of this litigation. What's unusual in this case is the absence of any explanation being
Yes,
put
there
forward.
doesn't even seem to be any theories about what it, or certainly
Precisely.
none in the Supreme Court.
Precisely.
So-
And actually it's the absence of those theories which gave rise to this case being important, because once you had the presence of a theory, individual claimants would have been far better equipped to say, well, I fall within that sort of category myself. It's what was referred to in the Supreme Court as the statistics plus argument. Here are the statistics. I can show that in addition to those statistics, I am likely to fall into that category.
Would it have made a difference? Maybe this is a stupid question, but would it have made a difference if the explanation had been known, but there was still the statistical imbalance? So, if the if there was an explanation that was not, the question makes sense, that was not connected with age, so is one of the factors here, but it's having an age impact, what would that do to the case?
Well, on the judgment as it now comes out, arguably nothing.
Well, that's sort of where I was heading with this.
Because the reality is, if all you need is the group statistics coupled with the fact, in this case, of failure,
Yes.
nothing else matters. Where I suspect it might have made a difference factually to the progress of the case is if you had some inkling as to what it was that was underlying the statistics. You might have said, well, actually one can see that claimants X to Z might be affected by this.
Yes.
Claimants A to C are unlikely
The individual
to be.
impact would be clearer. Yes.
And that probably survives this judgment, because it would come back to the point that Lady Hale made in the course of it, which is if there are known reasons or demonstrable reasons why somebody fails the test, irrespective of the statistical position, you could say, well, if that reason falls outside the reason that is known to affect everybody else, then they don't succeed.
Yes. Yes.
Because effectively you'd be saying you could show that the phenomenon which has given rise to this simply isn't what the operative feature is in this case. In principle, at least.
Okay. But I can see that put in those terms, if statistical imbalance is enough, it's going to put far more of a weight on objective justification.
Yeah. And all of these things admit of counter-arguments. So you could equally see somebody saying, if as a matter of fact I am at a statistical disadvantage by being over the age of 35 or black, for example, then that disadvantage survives, notwithstanding that there may be other features in play. So I'm still at the disadvantage, but it may be that I'm disadvantaged to a lesser extent than somebody who does turn up for the test or who does do the revision. And that may sound in quantum. Again, all of these would be highly fact sensitive.
Beguilingly simple, I think you described it. Once you start digging down into this, it's much more challenging.
Very much so.
I was reading an article about this case that was talking about the impact on equal pay in the Armstrong case.
Yes, I saw that too.
And it struck me, and that's partly what was underlying if we had an explanation here, would it change the outcome? And potentially it wouldn't change the group outcome.
Yes.
It seems then, it would then seem out of line for, in the equal pay case, if you have statistical analysis but you can prove it's nothing to do with the gender, the pay differential has nothing to do with gender, that then doesn't even take you into justification. That becomes a complete answer. So you can explain one but not the other.
Yes, and if we're thinking of the same article, the premise of that article was that the Armstrong line of authority was wrong, and that it was a shame that the Supreme Court in Essop hadn't taken the opportunity to say
as someone who acts predominantly for employers, I'm not sure I'd start with that. I agree with that starting point, yes.
I mean, I'm not sure I agree with that starting point either, and perhaps you wouldn't expect me to suggest otherwise, but I think there is an important distinction between the equal pay claims. I do a lot of equal pay work myself. There is, of course, a wholly different framework, albeit that it is clearly a species of sex discrimination, surrounding equal pay cases. And the way in which the Armstrong line of authority looked at those matters was really to say, well, once you can show that actually there is something wholly different at play, the inquiry stops there. Actually, that's not really different. It may be dressed up with different language, but that's not really different from Lady Hale's position in this case, which is if an employer could show that different reasons were at play, one might take a different view of the value of the particular claim. I accept it's a different route to the same conclusion, but whether it actually marks the sea change that the particular article suggested, I question. Perhaps for another day.
Another day, yes. I can see another podcast in the making.
Yes.
Fantastic. Okay. So in wrapping up, obviously significant case, likely to affect the way discrimination cases are, in many cases, are run in the future, and probably more of a burden for employers to put up with, because it's going to be easier to challenge.
Yes.
Yeah. Just a quick question. Statistical imbalance. Not so much focusing on the facts of this case, but in terms of what statistical imbalances are needed. I know the case law says you're not looking at something that's a quirk or an accident of statistics. If you were looking at this in the abstract, is there any thoughts you're able to give in terms of what sort of statistics or how what sort of statistics are needed to show that there is a statistical imbalance to get this sort of challenge off the ground?
Well, in this case, there was a situation where the test had been running for a number of years, and the analysis showed that across that period there was a similar occurrence of the same result, which tended of itself to point to the absence of some quirk or peculiarity affecting a particular cohort of applicants or candidates. As ever in these cases, employers will point to the absence of data over the relevant period, or the absence of a properly sized group, or the absence of a proper control group, or the fact that other features were at play. So I think with all of these cases, from an employer's perspective, one will be looking very carefully at how reliable the data really is. From the employee's perspective, you would expect, no doubt, them to be saying, well, once you're seeing the same sort of statistical result over, frankly, any significant period, or any period at all that shows a significant imbalance where the same test is being applied, that would be sufficient. These are fact-sensitive questions. No doubt Battleground will shift to that sort of area as well. But I think, on one view, these questions will only affect people in very extreme circumstances, because, as I say, the dearth of case law raising this point in the past tends to point to the suggestion that in many cases either people feel that they will just get on and run objective justification and have done with it, and that might be a strategic decision, or they will recognise that there will be other factors which are explanatory of the particular statistical imbalance. And so it may be that, as with all cases that test at the extremes of the situation, that the cases most likely to be directly affected are a relatively small cohort. For the rest, it will be a more diluted version, I think, of having these principles restated so that everybody knows where the goalposts are.
Well, we'll see. It could be interesting. I can see, with thinking about the Armstrong case, with gender pay regulations and so on, well, that will throw up a whole series of statistics, all of which employers will say are meaningless because of the way the tests are run. But you could see claimant lawyers maybe quite interested to get hold of that. So,
I mean, these cases do throw up fascinating arguments, and I'm sure
spoken like a true barrister. Yes, it's a really interesting point. Yes.
Truly fascinating, and I must get out more.
Well, actually, I was going to finish. I always try and ask a question off topic towards the end of the podcast. So it's books, music, or hobbies. Which question would you like? Books,
I'll take hobbies, please.
All right,
Nick.
Please. So for the listeners, your favourite hobby and why?
Okay, my favourite hobby is sailing.
Right.
I do a lot of sailing. And the reason is, I think, because it's totally different from what I do every day in terms of it's not sedentary, you're out in the elements. It's intellectually stimulating, which isn't totally different from what I do every day, but it's intellectually stimulating in a totally different way. You're pitting yourself against the elements, and you're very much aware that actually, in many cases, you're only just in control of what's going on.
It's probably a bit like being a barrister on occasions.
Quite a lot like being a barrister, yes, absolutely. But you come back from a weekend or a few days sailing and you feel exhausted in the nicest possible way.
And it also clear the mind because you're having to focus completely on what's going on around you.
Absolutely right. So it stops you focusing on all the other things, all the litigation you're involved in, all of the things that go into being a lawyer, and just allows you to do something else. It's very refreshing.
And do you sail on your own, or are you part of a crew?
I sail with my husband,
right,
predominantly, who was very clever because I had done no sailing until I met him, and he introduced me to it in the Mediterranean, which is non-tidal and sunny, and lots of long lunches and so on. And sailing in the Solent, which is where we do most of our sailing, in December is a little bit different.
That's hardcore.
Yeah, it's hard work.
The only time I've sailed, we were staying at a hotel in the Mediterranean, and I thought, the sailing, how difficult can it be? So I booked an hour's lesson with someone, which consisted of them taking me out on the boat in and out a couple of times. Then he jumped over the boat and said, "Okay, go do it." It was like, so that didn't work so well.
Yes, I'm sure it's actually quite sink or swim.
I was definitely on the sinking stage.
Yes.
Fantastic. Well, listen, Naomi, thank you so much for joining us. It's been good fun and really informative. And I do think it's going to be a case that gets cited a lot in the foreseeable future. So, and I'll be interested to see what the final outcome is. So, thank you very much.
Thank you, Nick. Thanks very much indeed.
So, that concludes this podcast. We hope that you find it and others in this special Another View series helpful. If you have any comments or questions, please email Nick at nrobertson@mayorbrown.com. This podcast is an overview of the cases and law, and how the law will apply in any particular case will depend on the individual circumstances. Listeners should seek legal advice if any of the matters discussed are relevant to a specific issue or concern. Thanks for listening.